Every summer, thousands of holidaymakers flock here to the British seaside to enjoy the warm weather, the pebble beaches and the amusement arcades. But there's another side to these shores, a sinister underbelly of violence and murder, where sins are washed away in the tide and where the seafront is stalked by sadistic killers who, like the ocean itself, have no respect for human life. My name's Dr. Nell Darby. I've written extensively about the history of crime, researching the reasons why people kill. Over the course of my career, I've developed a keen eye for spotting trends in a killer's behaviour. Nowhere are these trends more striking than in the not-so-sunny seaside towns of Britain's coastline, which have always seemed to attract an extraordinarily high number of murderous rogues. In this series of Murder by the Sea, I examine a selection of chilling new cases, many of which have never been featured on television before. Join me on a journey to the cliff's edge, where the land meets the sea, and where life meets death. John Keoush was an anonymous farmer's son from the Isle of Man. On today's Murder by the Sea, we look at how this known sheep stealer committed patricide and thus became an infamous part of the island's criminal history.
The Isle of Man is a relatively small, rocky outcrop. It's just 32 miles long by 14 miles wide that squats between the west coast of England and the east coast of the island of Ireland. It has, for centuries, been a tourist destination. People go there drawn by its temperate climate, its rugged scenery, its beautiful beaches, and they've been going there since early Victorian times.
Obviously a small island community, pretty low population. We're talking around about 50,000 people. The industries were farming, fishing and tourism. So it was a real seaside attraction. But alongside that, you had the rural community. So farming was still very important, and there were sections of the Isle of Man which were very, very quiet, very rural, low population, lots of fields, very, very small communities. And so that's where the Keoush story unfolds, really, one of those tiny communities called Solby, which is an Old Norse word meaning farm of the cleft.
This is a very isolated place. You haven't got modern transport, so if you're farming in this rough terrain, you are quite isolated. You're forced in on each other for friendship, for companionship. So if there's an argument, there's no way you can really get away from it. You can walk out, you can go for a walk to unleash tension, but you can't drive off somewhere else. You can't really easily go and live somewhere else. You're all very reliant on each other.
You find that certainly in rural areas, the communities can be an awful lot closer because they're small in number and they're very much isolated in many ways. And so sometimes it can be far more difficult to get the trust of the community, to get to open up and give information, because there is a reluctance often to partake in investigations. And of course in rural communities often the familial setup is quite close, is quite different in that people are related to one another, cousins, uncles, brothers live within that community. Again, which adds to that difficulty of trying to get information, trying to obtain witnesses.
The Isle of Man had begun to shift towards a more British-informed policing system, but you have to recognise it's a rural community, it's not a particularly wealthy community at this time. The people operating the system are generalists. They weren't used to dealing with murders because thankfully, in a population of only 50,000, you didn't get very many murders.
And all of that helps explain how, in 1872, an impoverished farmer came to be hanged on the Isle of Man for murder, despite the fact that no one seemed able to agree exactly how he'd killed his victim.
This is a really interesting case, both because it's a case involving patricide, the killing of one's father, and that it had repercussions in terms of it being the last time a man was hanged for murder on the Isle.
John Kewish was 40 years old. He was the eldest of 7 children to a farming family who existed, because lived would be too kind a word, in abject squalor on the edge of a small village near Douglas on the Isle of Man. By early 1872, 5 of John's siblings had left home, and the ramshackle farmhouse now held just 4 inhabitants.
He lived in a farmhouse with his mother, his father and his sister, who we would now describe as mentally disabled. A little bit down the hill was another family in a cottage, and then a little bit beyond that was one of his brothers with their family. So it's easy to think of this in quite an idyllic way, and actually the reality was very different.
Well, this was a well-established family on the Isle of Man. The Kyoshes were farmers, so the father, John, had been farming for decades. He seemed to farm between about 20 and 26 acres in the northern part of the island. So this was a family that was well-known, well-established there. John, as the eldest child, was the one expected to follow his father's footsteps, to help his father with the farm, to take it over. However, he is said to have been simple-minded in the common parlance of the time. So that might have given his father frustrations about his eldest child and about who would inherit this farm. In addition, there later became allegations that there was this ongoing dispute between father and son. Some sources say it was about land, others simply about money. So there were conflicts between John Sr. and John Jr., but some of these only came to light after his father's death.
John Jr. was no stranger to trouble. He had a record for stealing sheep, something which would not have endeared him to the local farming community, and he had been embroiled in a bitter row over money with his father, John Sr. The dispute was only resolved when John Jr.'s mother, Mary, brokered a peace deal by which John Jr. promised to pay his father the following year 1 cow. Apparently a valuable cow, since that would have written off the debt.
The older Kewish was regarded as violent, unpredictable and difficult. The younger Kewish was a convicted sheep stealer and regarded as not fully capable. And the younger daughter seems to be kept in a very poor condition by the family and then ended up in an lunatic asylum. I think we can see this as a family at the margins.
By March 1872, the family had descended into 2 mutually hostile camps. John Sr. lived at one end of the farmhouse. John Jr. and his mother Mary occupied the other end.
So we have this family living together and not together. There were suggestions that the victim had been abusing his wife, and that was one of the reasons Kewish reacted so negatively to him. There was this ongoing dispute, and at the time of the murder, Kewish was meant to hand over the cow in a few days' time. Kewish had been heard saying he was going to give his father a good licking, so he was indicating he would physically assault his father. And his mother was heard warning him not to finish him. So, you know, don't go too far, don't kill him. So things were obviously simmering in the run-up. And on the night of the murder, the last time the victim was seen by somebody who wasn't suspected of involvement in his death, he had been left in the house with Kewish and Kewish's mother. So there's a window which is probably an hour when the murder took place.
Around 9 o'clock that night, Mary Kewish found John Kewish Sr. lying with 2 deep stab wounds in his chest and 4 more in his back. What Mary did next was, to put it mildly, unusual.
The family, as would be traditional, prepared the dead man for burial. So they washed him, they put him into new clothes. And it was only the night before he was due to be buried that the police intervened and said, look, there has to be an autopsy. And this autopsy immediately revealed that he died through wounds, so it had been a violent death. And as soon as that was confirmed that it was a violent death, John Coish was the immediate prime suspect.
Thomas Coish, who was the younger brother of John, informed the police, the investigating officers, that there'd been a long-standing argument, quite an extensive argument, between John Jr. and his father, John Sr. As a result of that, the information about the argument and the fact that John had previous convictions was enough, certainly in those days, for the police to arrest John on suspicion of the murder of his father. And he was actually interviewed and charged with the murder of John Sr.
The fact that John Coish was immediately the suspect shows how he's regarded by those around him. You had locals prepared to say that they were aware of this disagreement. There was the whole legal side of it. Obviously, this is not a very showy cause of death because the family were able to wash and prepare the body for burial, and you could imagine a scenario where they're doing that in order to cover things up.
So this case is one where the deceased had sustained 4 penetrating injuries to his body, and it was established that the weapon was a pitchfork, and that would only really become evident once the post-mortem examination had taken place, because there was some confusion at the time as to whether or not the individual had been shot.
The autopsy revealed a number of wounds to the back, including some fatal wounds. The suggestion was it was due to repeated attacks with something like a pitchfork, and pitchfork was the #1 focus of the discussion. The autopsy was also very categorical. This could not have been accidentally self-inflicted.
My strong feeling is that this was a quarrel gone wrong, and I think that's partly because of the likely murder weapon, which was a pitchfork. Pitchforks were common implements on farms, so it was something that would have been lying around. So I suspect there was an argument between father and son, and John Jr. reacted by picking up this pitchfork and just stabbing out of anger of his father. And if he was simple-minded, there might not have been that awareness of the consequences of doing something like that. You might not have realised that he had killed his father. He might just have been trying to injure his father without any kind of strong awareness that this could cause a fatal injury.
So in this situation, it seems that there's been a family dispute. The son has killed the father. As tragic as that is, this can be fairly common in some cultures and some groups. These situations can unfold, particularly where there's levels of dominance and power plays between individuals.
There was never really any doubt that the murderer was from outside the family because of the isolated nature of the location and how the family lived. The police were kind of thinking it must be somebody within the family, and likely one of the sons. And the fact that this incident had taken place on the farm using an implement within the farm, it hadn't been brought in. So they very soon focused on the eldest son as being the likely perpetrator.
Because he was such an obvious suspect, there was a very quick search of the farm and the surrounding area, and the police actually found they were looking for a pitchfork. Some of the locals had said they had seen a pitchfork on the premises, which had now disappeared. So the police went searching for a pitchfork, and they actually found a gun concealed in a roof space. So this isn't the sort of activity no one's going to notice. You know, there's a search going on. He's actually arrested and put into custody. There needs to be a quick report about how did his father die, and the coroner's inquest said murdered by his son.
While John Coish Jr. languished in jail awaiting his trial, the Isle of Man police collected what evidence they could, and some of that evidence involved testimony that Mary Coish had said to her son that he should give his father, her husband, a good thrashing, presumably because of the thrashings she had endured at John Sr.'s hands. And John Jr. had allegedly replied that only the application of rather more lethal force would solve the problem. There was another piece of evidence, or rather lack of evidence, which the police belatedly, as the trial approached, uncovered. They heard testimony that on the night of the murder, John Coish Jr. had been wearing a particular pair of trousers, and that after the murder of his father, those trousers had been covered in blood. However, the police in the intervening weeks had not bothered to secure that evidence. Those blood-stained trousers had now disappeared. It was not the first and would not be the last flaw in the police case against John Kewish Jr.
There was a very lively journalism sector, so you found an awful lot of coverage of not just the crimes but the trials, so you would really have day by day and sometimes more frequent updates on the really big trials of the day. And Kewish in particular was even given a moniker. It was called the Sulby murder, so it had its own brand.
There were multiple stages. So, you needed the inquest into the cause of death, which actually indicated that the inquest jury thought that he was the murderer. You then had him set aside for trial, and he faced a trial in the early summer of 1872.
He was charged with the offence of patricide, and of course that's the murder of one's father. And certainly in those days, patricide, it was considered a particularly heinous crime by some of the legal systems and obviously the systems on the island. And those legal systems, that judiciary if you like, demanded that that particular offence should be met with the most severe of punishment. The father was the person, the glue if you like, that held the family together, certainly from a financial point of view and support in many, many other ways. It was the man of the house, as they used to say. So to kill your own father was considered a particularly heinous crime.
By the 1870s, a lot of the really distinctive practices of the Manx courts have gone. You had a jury who sat in the jury box, all men. I'm afraid women weren't allowed to sit in a Manx jury until 1978. You had professional lawyers who didn't dress quite the same as English barristers. They were Manx advocates, so that was a mix of barrister and solicitor, but they would look quite similar. And the trial would be presided over by one of the two principal Manx judges. They were called Deemsters, and that is actually derived probably from the Old Norse, so a very ancient part of the Manx constitution. But in many ways, they would look like a Crown Court judge. The defence argument was that, yes, John Kewish's father was dead, but John Kewish had nothing to do with it. A straightforward denial of his factual cause of his father's death. And his defence advocate made quite a lot about the absence of any direct evidence, so anyone actually having seen the murder carried out. They stressed the weakness of the Crown case, if you like. The Crown's argument was there were only really two people who had the opportunity, because we have a period when he's alive, we have a period when he's dead, and in between that period, the only people we know were there were Kewish and possibly his mother. So the opportunity is there. The motive, we have the fractured family and the actual legal dispute, and obviously given that the medical evidence was that a pitchfork was used and a pitchfork had gone missing from the farm, the argument was that he, as a middle-aged man in good health, would have been more than capable of using it to inflict the wounds found upon the dead person. A number did give evidence, including actually his mother. She acknowledged that there was a dispute in the family. She didn't incriminate him. They didn't make a lot of it, but they did sort of, as you would expect, go for the how do we know it wasn't some stranger. But they also tried to cast doubt on the mother. So one of their responses to the prosecution's suggestion that there were only two people, around when the murder would have happened was, well, how do we know it wasn't his wife? They were, on very poor terms with each other. How do we know that she didn't carry out the murder? But I suspect the jury looked at this quite elderly lady, I think she was 69 or 70, and compared that with the fairly strapping middle-aged son and probably had views as to who would be more likely. So you have the trial go on for a number of days. It's very well reported in the Manx press. It's a really significant story. And then at the end of the evidence, the 12-member jury went away, deliberated, were called back by the Deemster that day and said, have you made a decision? And he was told that they were deadlocked. So they didn't have a 12-0 majority for acquitting, but they didn't have a 12-0 majority for conviction either, so they were a split jury.
It was an admission which did not please the Isle of Man authorities. The island's Lieutenant Governor promptly locked the jury up overnight and deprived them of food and drink as a punishment or as an encouragement to get their act together and reach a verdict. As unusual as that sounds, under the archaic Manx law, that was a perfectly legitimate sanction for a jury which couldn't decide. But a night without sustenance did nothing to ease the jurors' worries. Once again, they returned to court and told the Deemster, "We cannot reach a unanimous verdict. 5 of us want to convict John Kewish Jr. of the murder of his father, but 7 of us want to acquit him."
Some of them felt that the prosecution simply had not proven the case. So they felt actually, beyond reasonable doubt, we can't say that he killed his father. We don't think it's been proven he did what they're saying he did. But a number of them would have acquitted him on the basis he was too simple-minded to be fully responsible. So they, even though this was not a point made by the defence lawyers, they would have gone, actually, this man is insane, effectively. He shouldn't be held fully responsible for what he does. So that deadlock stayed. The next morning, the Deemster calls them in again, and by that point, one of the jurors has become ill. So a doctor is called to look at the ill juror and says, actually, he is not healthy enough to continue. He should be discharged as unfit. So this first trial, the jury deadlocks and then is discharged. Kewish's advocate basically says, you've had your shot. You've had my client, you've put the evidence before, you have not convinced a jury to convict him, therefore he should be acquitted and face no further proceedings. The Deemster did not agree, and instead he ordered a retrial. So wipe the boards, start from scratch again with a fresh jury and a fresh trial.
There was always this feeling that John was either innocent or he couldn't be held responsible for his actions because of his mental capacity. And so this gave it a lot of notoriety, and obviously with the fact that he was tried twice, and in the first trial the jury couldn't decide on whether he was responsible for the murder or not. So this was really newsworthy because it was a controversial case where if even the jury can't decide and the trial has to be abandoned and a new trial started, this is really significant. It's not a clear-cut case where the jury comes back in like half an hour and says, yep, he's definitely guilty. They couldn't work it out. So if they couldn't work it out, how could the public?
It must have felt quite eerie for Kewish because it's the same building, it's the same Deemster, it is a different jury, but very much the same sorts of people. These are Manx men who are sat there, many of the same court officials, and the evidence hasn't changed. This isn't one of those trials where there has to be a retrial because some part of evidence has been found to be tainted. This is simply that set of 12 people couldn't decide, let's try it with a new set. In the first trial, his defence lawyer argued he had nothing to do with the crime and nearly managed to succeed in convincing the jury. The lawyer in the second trial pleaded in the alternative. So they argued, my client did not commit this crime, and if he did, he was so insane he should not be punished for it. Now, pleading the alternative is not always a really good idea. Put yourself in the position of the jury. The jury are being told, for one of these two incompatible reasons, you should acquit my client. Because saying he did it but insane is different from saying he didn't do it.
So the defence of not guilty by reason of insanity is used in a very, very small number of cases, and even people who have recognised mental illnesses and may have even been receiving treatment, often it's not even seen as a mitigating circumstance in these situations. It's very difficult to understand how somebody could commit these crimes, particularly if they tried to get away with it, that they knew what they were doing.
So the second jury didn't need 14 hours, didn't deadlock. Within an hour, they returned a verdict of guilty. And in Manx law at the time, the only punishment for somebody found guilty of murder was death. So Deemster Drinkwater sentenced Kewish to death. Kewish's response was stolid. So he's reported as being very calm, very difficult to read as the sentence is passed on him. His family must have been distressed because we have members of the family visiting him to try and persuade him to confess and to clear his mother, but we also have members of the family arguing that he should not be executed. Everybody who commits murder has to be sentenced to death. In fact, a very large number of people convicted of murder are not actually executed. They receive the prerogative of mercy and typically receive life imprisonment or transportation or something like that. In both trials, they completely stuck to the pitchfork discussion. So this gun had been found, and it had been found in the search for a pitchfork. It's only later that Kuish himself introduces the shotgun argument.
Initially, John didn't confess to the crime. He said he wasn't guilty, he just didn't do it. And he kind of stuck to that story for quite a while. And it was only while he was in prison that allegedly he confessed either to a cellmate or to the jailer that he'd killed his father.
Initially, he was optimistic about getting some sort of pardon. But as gradually the reality of the situation settled in and it became clearer that he was going to be executed, and obviously there were religious arguments being made to him about the merits of confession. There were the family arguing that if he confessed, his mother would be freed of any shadow. He later admitted that he shot his father deliberately. Not stabbed, not used a pitchfork, but shot his father. He referred to it having been at the instigation of the devil, which was a fairly conventional form of language at the time. His father, he said, had been sat with his back to him in the fire, by the fireside, and he'd simply taken his gun and he'd killed him. It was, I should stress, a shotgun. So his argument was that he'd fired once, he'd inflicted these multiple wounds with the different pellets of the gun, and his father had died fairly soon afterwards. He argued that his father said "she creased" as he died, which was "God bless all" in Manx. And he also says he did it because of the money. He was so angry over the money, that the settlement, this dispute, this money he owed his father, that he had killed his father.
I think we have to take his confession about having shot his father with a pinch of salt. He claimed that he'd shot his father several times and that he died instantly, whereas actually that doesn't square with the evidence from doctors and from people at the scene that he'd been stabbed 3 times with a pitchfork. You know, it's completely different. But it's whether John, with his state of mind, getting confused about what he'd done to his father or coerced into saying something that he didn't believe. He knows they want him to confess to this murder, but he can't really remember what happened, so he just says the first thing that comes into his head. And obviously, you know, shooting someone dead, that's kind of like this well-known way that you can kill someone. Or conversely, it could even be the person that he'd confessed to wasn't a reliable source of information and had kind of made up this confession. If they've been approached to have a say in this story, they might welcome that opportunity to be a part of this case. So I don't think he was kind of character who would say it in order to sound more exciting or more notorious. I don't think he had that kind of mentality.
So there's some confusion as to whether he was shot or whether he was stabbed with a pitchfork. So it creates a little level of ambiguity as to how this crime unfolded. And anybody who's committed a crime trying to get away with it will be quite keen for the police and the authorities to not be able to present this information reliably in court. And when we think of this idea of beyond reasonable doubt, if you are an offender and you committed a serious crime, you will try to instill this ambiguity in a jury in order to try and get away with your crime.
There was no such thing as having, you know, an appropriate adult with somebody who was known to have kind of intellectual issues. And so John was kind of left on his own, really. So there's a lot of concern about how he was treated then, but it was a completely normal way for people to be treated in Victorian times. And there was this kind of very slow move to recognising that some people weren't responsible for their actions, that they did face issues, and those issues should be taken into account. And I think that's why you see there's a lot of sympathy locally for John.
You have Kuish confessing that he has shot his father dead for money and denying that a pitchfork was used. So one possibility is that the Manx medical authorities were wrong, that they miscategorised the injuries as caused by a pitchfork rather than by a shotgun. Most commentators, I think, would say that's a bit unlikely. So you're left with a situation where a man is confessing to killing his father but wants to put forward a particular story about how he did it, which differs from the medical evidence.
So obviously at this time then we didn't have the techniques that are available to us in a contemporary sense. But things like ballistics and firearms, they would have been well understood in this context. And it would be certainly possible to do a post-mortem examination and examine the body for ammunition and bullets. And in this case, our understanding is that those weren't found. So we had 4 penetrating injuries that were consistent with a pitchfork. So when someone is shot, a few things happen. So the bullet initially goes into the body, and when it's going through the tissue, it creates what we call a temporary cavity. Essentially, the body starts to stretch and then snaps back to its permanent cavity. This is the track that the bullet takes through the body, and it's the track that can be kind of reconstructed by a pathologist using a probe. So that track will be almost like a small tunnel where the bullet has traversed through the body. So a penetrating injury with a pitchfork could create these almost similar tunnels of damage through the body, but they won't be associated with all the other things that you get from a gunshot injury, such as sooting or such as this temporary type of cavitation that creates enormous amounts of tissue damage.
I find this really interesting, the aftermath of the second trial when John has been convicted of murder and sentenced to death, because yes, you get the usual procedure with a lot of these cases where appeals are put in, where petitions are signed by locals saying don't kill him. But it's significant as well because there was like a wider protest on the Isle of Man where when preparations were being made to execute John, you had locals refusing to get involved. So like local carpenters didn't want to build the scaffold, local suppliers didn't want to supply the equipment to construct it. So they had to go to England to get materials, to get workmen. They even had to bring an executioner in from the mainland to kill him because locals didn't want to see him die. They didn't want to have that kind of stigma of having been involved in it. So it's clear that there was a lot of sympathy or empathy towards him from the local community and that they didn't want to see him die.
The Act of capital punishment wasn't abolished on the island until 1993, some 120 years later. And of course, the Isle of Man is quite unique. Although it is a British protectorate and comes under the government of the UK, they have their own parliament, Manx Parliament, known as the Tynwald, and they make their own regulations and statutes and laws and carry them out. Generally, the United Kingdom, in fact, almost exclusively never becomes involved. Between 1972 and 1993, 5 other people were convicted of murder and sentenced to death on the island, but all 5, of course, had their sentences commuted to life imprisonment. And as I say, it wasn't until 1993, that capital punishment was finally abolished on the Isle of Man.
It had been decades since there'd been an execution, and the previous executions had happened in a very different social context. And actually, since the previous executions, the Manx government, the Manx Parliament, had tried to make fewer crimes carry the death sentence, and that had been rejected by the British government. So we have some evidence that the Isle of Man was not as pro-capital punishment as England. A number of officials resign rather than being involved in the execution. I think there was a feeling that he had done it, but that his mental state was such that it was simply not right to execute somebody. You're in a situation where not every murderer sentenced to death is executed, but some are. And so you need to have some way of distinguishing between them. And when the UK Home Secretary looked at the case, he gave quite a lot of weight to things that were against Kewish's interests. I think he was influenced by the fact it was a killing of a father by a child. Parricide is one of those crimes which has a really strong cultural resonance, so that didn't help him either. The Home Secretary ran through the sorts of things that he would look for to exercise the prerogative of mercy, and he simply concluded they were all absent. So all of the evidence and all of the arguments being put together by Kewish's team to save his life at this stage, Bruce was rejecting. But we then hit a very strange peculiarity of Manx law, which means that Queen Victoria herself had to become involved. English law says you're sentenced to death, and if nothing else happens, you'll be executed. The Manx law, in the early 17th century, we moved from this position, like the English position of, unless the prerogative for mercy is exercised, we're going to execute, to we want to find the will of the sovereign. The Lord of Man and the King of England were both absent from the Isle of Man. They hardly spent any time in the Isle of Man. So you have a problem of someone sentenced to death in a Manx court, and the power to pardon them lies across the sea. There is a huge national character called Illiam Doone, who was a leading figure in the Manx side of the English Civil War. And after the restoration of King Charles II, he very sensibly stayed well clear of the Isle of Man for a while, but then was assured that the Act of Indemnity, which meant that almost everybody who had rebelled against King Charles I would be spared prosecution, he was told the Act of Indemnity covered him. He returned to the Isle of Man, was promptly arrested, tried with treason, and executed. His plea for mercy from King Charles II reached the king after he was already dead for a week. King Charles would have given him mercy on the basis that he should never have been convicted because of the Act of Indemnity, but the logistics, the communications between the Isle of Man and London were such that the king had no chance to intervene. So as a result, Manx law was changed to specifically require the will of the sovereign. So what this means for us is that when Cuish had been sentenced to death, if he was an English person, the Queen does nothing, he gets executed. Because it's a Manx case, the Queen has to decide to kill him. So the Home Secretary writes to the Queen in the most apologetic terms you can imagine. I'm terribly sorry I have to ask you to do this. I'm going to get Manx law changed as quickly as possible, but you have to decide whether or not this man dies. She can't do nothing. If she does nothing, he just sits in prison waiting for her. So she signed the death warrant. So she personally ordered the death of John Cuish. And she said, "The Queen has with much pain signed this paper. It is very strange that this should have to be done in the Isle of Man. The Queen hopes never to have to do it again. She has read the evidence. He seems a poor creature, and the Queen has her doubts about the matter." So Queen Victoria is incandescent. Her understanding of queenship is not that she kills her subjects, but that sometimes she will intervene to save the life of a subject who merits death. A profoundly different view of her relationship with her subjects. That suggestion about having doubts and him being a poor creature might indicate she had personal doubts about whether she should be executed, but as a good constitutional monarch, she knew the person who should advise her was the Home Secretary. The Home Secretary was advising death. And so she signed.
At 8 a.m. on August the 7th, 1872, Calcraft led Cuish to the gallows. He pulled the white cap over Cuish's head, tightened the noose around his neck, and pulled the lever which dropped him through the trapdoor. He did so in front of an invited audience of press and local dignitaries. Justice of a very rough and ready sort had been seen to be done.
As he approaches his final moments, there seems to be some evidence that John Cuish was reconciled to his fate, which we see partly in his willingness to acknowledge he had killed his father, but also in other parts of discussions. And his last words were, "God bless all my good neighbours near me." He hadn't been a great neighbour, so maybe recognising that he had his faults against his community. And I think, remember, he told a story earlier that his father's last words were a blessing upon him. So maybe that was something that was working in his mind as well. Immediately a black flag is raised over the prison, which at that time was Castle Rushen, which is actually a medieval castle. Cuish is then buried in prison grounds. He's not released to his family. His family had asked for his body, but he was buried in prison grounds.
It would have had a severe impact both on Mary, the mother, and on the remaining children, because the whole future of the farm was tied up with the two Johns. You have this father, the 60-year-old John, who has been farming all his adult life. He knows the farm, and he's teaching the eldest son, as is traditional, how to take over that farm after him. So with the absence of those two figures, you have a widow, a couple of daughters and a couple of sons left, and their family has been blown apart really by this event. And then you have to find ways of ensuring your own survival, because previously you just assumed that your survival was okay because the father and the eldest son would take care of it.
He was ultimately hanged for his crime, and this created some outrage in the community because they didn't really want to see even one of their own sort of being treated in this way. And often we find in these situations, particularly in kind of like native populations, there's a big kind of mismatch between the authorities and the police and how communities like to deal with situations on their own. So although there was a lot of anger at what had happened, at the same time they didn't want to see somebody committed to the death penalty.
There were often protests when people were hanged, when they had the sympathy of the public, and it's clear that on the Isle of Man people did not want him to die. They would have protested right up until the last minute. And you have a case here where even the Queen Victoria, she had to give her permission for this execution to go ahead, and she was reluctant to do it. Murder was rare on the Isle of Man, and even before this case it had been decades since another man had been hanged for murder. So it didn't happen very often. However, John Kyash was the last man to be hanged on the Isle of Man, but he wouldn't be the last man sentenced to death.
Whether John Kyash Jr. did commit the crime, the sin of patricide, whether he did kill his own father, or whether he was, as his defence barrister claimed, simple-minded, as mentally deranged as the sister who was locked up in the family's attic. That's a question that can't be answered. It's a question lost in the mists, both of Victorian jurisprudence and the murky mess that was law enforcement in the 1870s.
I'm sure he killed his father. I don't believe necessarily that he knew what he was doing or that it was premeditated, but I can't see that an outsider would have come in and killed John without anybody suspecting another individual. And given the nature of the family, the location, I believe it's more likely that there was a dispute between John and his father that resulted in the older man's death.
The thing about cold cases, or legacy cases as they're sometimes known, is they are very fascinating in many, many ways and can be extremely useful and instructive for investigators today. What can be frustrating, of course, as in the case of John Kyash, is the further back you go, the more difficult it becomes because of the lack of case papers and exhibits, etc., which are understandably lost or deteriorated over time. And there were questions, many questions, for instance, that if I was reviewing this case as a cold case, sadly, they're a mystery at the moment. For instance, what was the argument about between John and his father? What was the extent of the argument? When we talk about John's criminal history, well, how much of a criminal history? Was that enough? Sheep stealing and petty theft? Would that be enough to justify arresting him for the murder of his father? Certainly that wouldn't be so today. I think we'd be looking for far more evidence today. But what I do find interesting is that even though it's that quite lengthy period of time back, even then there were people on the island and professional people, apparently medical professionals, put in statements to the court stating that they felt that John wasn't capable of understanding the severity of his crime. So there were people even in those days that sort of sympathised and understood this issue of mental illness.
I think today he would have been found to have been of unsound mind or, not guilty because of his intellectual disabilities. If you can't understand what you've done and the difference between right and wrong, then how can you be convicted of a premeditated murder? And I think even the fact that Victorian juries struggled to find him guilty is significant, because it means that he couldn't really be deemed responsible for his father's murder, even if physically he carried it out.
When you look at the investigation itself, the length of time the investigation took, and when you bear in mind that it was the end of March when John Sr.'s body was found by his wife, And it's the 1st of August that year that John is hung. So within 3 or 4 months, not only is the investigation complete, but the trial and the sentence has been completed and he's been executed within 4 months. I mean, that's staggering when you compare to today. An investigation into that type of crime would last months and months and would be far, far more in depth. You'd look at other suspects, other possibilities. The whole family would be interviewed. The neighbours, the community would be spoken to in depth and statements taken. All these issues and the pathology, the weapon, you know, the type of wound would have been far more forensically looked at today. And really speaking, we shouldn't compare because that's how it was. That's how policing was then in comparison to as it is today.
I think John Cursh is one of those forgotten stories. There isn't the drama of some of the very well-known murders we find in England and Scotland. It represents a moment when the English influence was very pronounced in the Isle of Man. So not only are all the decisions about Cursh's execution once he's been sentenced to death made by English actors, the actual way in which he's executed follows English law rather than Manx law. Manx law is changed to come into line with English law. So I think there's a certain high point of Victorian colonialism in relation to the Isle of Man, which we see around Cursh in the 1870s. I mean, in many ways, it is a very, very sad story. This isn't a grand story. This is a small family which has 2 people dead, 1 murdered, 1 executed.
After 2 trials, John Keaush became the last man to be executed on the Isle of Man. But questions remain about the extent to which he was responsible for his father's murder and how exactly the older John died.